Zuber and Company, fire forensic experts and forensic engineers. Seeking answers from ashes. Seeking answers.
Welcome to The Explainer. Today, we're diving into a question that seems, super simple, but it's not. It's actually at the heart of some major legal battles, and the answer could have a huge impact on you and your family. Okay, let's just get right to it. If you're murdered, does your accident insurance actually pay out? I mean, it seems like a no-brainer, right? Of course it should. But you'd be surprised. In the world of insurance contracts, things are rarely that black and white, as one family unfortunately found out. So this all starts with the tragic story of Balram Mulchandani. He had a personal accident policy, did everything right, paid his premiums, but then, one day in 2009, he went to work and just never came home. The police investigation revealed the awful truth. He'd been murdered over a property dispute, and when his grieving family tried to file a claim on that policy, the insurance company said no, flat out refused to pay. And that kicked off a huge legal fight. The insurance company's argument was, look, this was a murder simpliciter. That's a fancy legal term for a simple, straightforward, intentional killing. And they said an intentional act is not an accident. But the family's argument was just as powerful. They said, wait a minute, from Mr. Mulchandani's point of view, this was completely random and unexpected. How is that not an accident? So who's right?
This whole case really boiled down to one crucial question. When we're talking about what an accident is, whose perspective do we take? The person who did the killing or the person who was killed?
And this is where things get really interesting. The court dug into a super old, really important legal text called Halsbury's Laws of England. And in it, there's this incredible line, which basically says that even a willful murder can be seen as an accident, as long as you're looking at it from the victim's perspective. So that was it. The verdict was in. The court said it's an accident. The test isn't about what the killer planned. It's about what the insured person, the victim, expected. And because Mr. Mulchandani had no idea this was coming, legally, his death was an accident. The insurance company had to pay up. Okay, so case closed, right? The rule is it's an accident if the victim didn't see it coming. Simple. Well, not so fast. Just when we think we've got it figured out, the law throws a huge curveball, because it turns out not all murders are treated as accidents. Let's look at another case, the case of Rita Davey. It involved an auto rickshaw driver, Dasarat Singh. He's murdered by his passengers. But here's the twist. Their main reason for being there wasn't to kill him. It was to steal his vehicle. And this one little detail forced the court to look at something new. Not just the victim's perspective, but the criminal's actual intention. So this case gave us two different categories of murder in insurance law. First, there's murder simplicore. That's when the primary, dominant goal is to kill someone. The court says that is not an accident. But then there's accidental murder. This is when the murder happens in the middle of another crime, like a robbery. The killing wasn't the main point, and that is considered an accident. So, back to our auto rickshaw driver. Because the main goal of the criminals was theft, stealing the vehicle, the court ruled his death was an accidental murder. It was secondary to the main crime. And so, once again, the insurance company had to pay out. All right, so we've got the victim's perspective, we've got the criminal's intent, but what happens when the whole thing is a lot murkier? What if there's no crime at all, but a medical emergency that leads to a death? This brings us to a whole new puzzle, the chain of causation. This one's called the Alka Shukla case. Picture this, a man is just riding his motorcycle. Suddenly, he falls and he dies. Now, the cause of death is determined to be a heart attack. So, is that an accident? The insurance company said no way. They argued that the real cause of death was a medical problem, not the fall itself. And this is the classic chicken or the egg problem, right? You've got two possibilities. Scenario A, the guy has a heart attack, which causes him to lose control and fall. Or scenario B, he has an accidental fall for some other reason, and the shock or the injury from the fall causes the heart attack. The whole case hangs on this one question. What came first? What was the real trigger, or what the law calls the proximate cause? Well, the court looked at all the medical evidence and they figured it out. The heart attack happened first. It was the internal medical event that started the whole chain reaction. And because the problem started inside his body, not from some outside force, the court said it wasn't an accident.
The claim was denied.
And that last case perfectly sets us up to talk about the fine print. You know, those words buried deep in your insurance policy that nobody ever reads? Well, there's a specific phrase that is at the center of all of these court battles: outward, violent, and visible means.
Let's break that down. First, violent. Now, this doesn't necessarily mean what you think it means, like a fist fight or something. In legalese, violent just means any kind of external force acting on the body. It could even be something subtle, like breathing in gas. That counts.
Next up, external. This is the big one from that motorcycle case. It just means the cause has to come from outside your body. A disease, a heart attack, those are internal. A fall, a car crash, an object hitting you, those are external. The injury itself might be internal, but the thing that starts it all has to be from the outside.
And finally, visible. This one's a little weird. It's mostly just there for legal emphasis. It doesn't literally mean you have to see a cut or a bruise. The law basically says that if the cause was external, then it was, by definition, visible in a legal sense. Kind of just lawyers being lawyers.
Okay, so we've been through a lot, different cases, confusing legal terms. So let's pull it all together. When a court is trying to decide if a death was accidental, they basically run it through 3 key tests.
First, there's the victim's perspective test. Simple. Did the victim see it coming? Was it unexpected for them? Second is the felon's intention test. This only applies to murders. Was the whole point to kill the person, or was the killing just a part of some other crime, like a robbery? And finally, number 3, the proximate cause test. What was the first domino to fall? Did it start with an external event or an internal medical issue?
So what's the big takeaway here for all of us? It's that the word accident on your insurance policy isn't just a word, it's a legal battleground. So here's a question for you to think about. Do you know what your policy says? Does it clearly spell out what it considers an accident? Or is it vague enough to leave your family fighting in court at the worst possible time? It's probably worth taking a look, because the answer could make all the difference.